Mic test, 1, 2, 3.
Mic test, 1, 2, 3.
Good test.
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 Just making sure y'all can hear me.
Yes, ma'am.
Good morning, y'all, and welcome to the March 11th, 2026 meeting of the Texas Commission on Environmental Quality. It is 9:30 a.m. For the record, I'm Chairwoman Brooke Popp, and I'm joined here today with Tanya Miller, and Katarina Gonzalez is virtual. We also have General Counsel Mary Smith and our interim Public Interest Counsel, David Timberger. For each item, that argument and discussion is allowed. We'll inform the parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit the registration table if you're here in person, or if you're on the webinar, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our absolute best to accommodate that request. For those making presentations, please wait to begin your presentation until I or Mary have asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. All right, Mary, first item, please.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Crystal Clear SUD to levy an amended impact fee. The applicant, the protestant, the ED, and the OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal, as the applicant bears the burden of proof in this matter. And so with that, we'll begin with a representative of the applicant.
Good morning.
Good morning.
My name is Elena Folgaris. I'm here on behalf of Crystal Clear Special Utility District, the applicant in this case. At this time, we would like to reserve any remaining time for rebuttal. The only thing we have to say currently is that we agree with the proposed order submitted by the ALJ in this case, and we ask that you grant Crystal Clear's application to levy a revised impact fee of $5,163. Thank you.
All right, thank you. We'll hear from the protestant.
And I believe he's virtual.
Mr. Benavides, are you there?
I'm here.
Oh,
You made it. Great.
When I protested this fee, I was suspicious.
Mr. Benavides, will you turn on your microphone?
Is it on? Oh, there we go. Oh,
thank you.
okay, good. Thank you. When I first protested this fee, I suspected that Crystal Clear did not have a solid reason to go ahead and levy it, double it from what it currently is. They submitted a study, which later on, when the SOA hearings, it came out that Crystal Clear itself admitted that they had submitted the wrong study, that study only supported 2,600, not 5,163. Now, yes, ma'am.
I just want to remind you that your any facts that you bring up during your argument have to have already be part of the administrative record or something that was entered into the record.
It was entered, yes, ma'am.
That is all that the commission can consider.
Yes, correct. So it's all part of the record, and if you read it, you'll see there that Crystal Clear itself admitted that they submitted the wrong study. For whatever reason, the ALJ decided to go ahead and allow Crystal Clear to submit some more paperwork over a year after the fact. Considering we were evaluating the original application, I found that dumbfounding. Now, there's been a lot of changes since then. For example, the president of the board resigned. All 3 incumbent board members that were up for election are out. The people have decided they've had enough of this. And furthermore, the manager that was there at the time has also resigned. So it's a majority new board now. I'm now a board member there too. And I'm out there to look for the interests of the Crystal Clear customers, not for management's whims. So I would suggest that the commission consider that Crystal Clear itself admitted that no, their study that they originally submitted did not support the 5,163. That is a fact. There's no question about it. If you look at the record, you'll see that. So I would suggest that you don't approve this increased fee.
thank you.
Thank you.
We'll hear from the ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. I am Kayla Murray, an attorney in the Environmental Law Division. With me is Justin Tack, manager of the district section, and we are representing the executive director. Pursuant to Texas Local Government Code, Chapter 395, and 30 Texas Administrative Code Sections 293.171 through 293.176, a district may apply for a new impact fee, which is defined as a charge or assessment imposed by a district against new development in order to generate revenue for funding or recouping the costs of capital improvements or facility expansions necessitated by and attributable to such new development. Crystal Clear Special Utility District has requested approval to levy an impact fee of $5,163 per connection, and the ED has determined that this proposed impact fee is reasonable and necessary to ensure that the district can fund capital improvements required to serve projected population growth and maintain system reliability. Joseph Benavides filed a timely hearing request, and this commission referred the case to SOA. After Mr. Benavides did not file pre-filed testimony, the applicant filed a motion for summary disposition, which was granted by the ALJ. The ED is in agreement with the PFD and recommends that the proposed impact fee be approved. Thank you, and we are available for questions.
Thank you very much. We will hear from OPIC.
Yes. Good morning, Chairwoman Pop, Commissioner Miller, and Commissioner Gonzalez, General Counsel and the Executive Director's attorney and staff. For the record, I'm Sheldon Wayne, representing the Office of Public Interest Counsel. With respect to the Commission's consideration of the proposal for decision and related record in this matter, after participating and examining the evidence and the argument that's been presented, OPIC agrees with the Honorable Administrative Law Judge that the granting of summary disposition was proper in this matter. This case concerns the imposition of an amended impact fee sought to be charged by the district. Governing law provides that if the district demonstrates that the proposed impact fee is reasonable, equitable, and necessary as a mechanism to finance improvements to serve the designated surface area, TCEQ shall approve the impact fee. In this matter, the applicant filed a direct case. However, the sole protesting party, Mr. Benavides, did not file a direct case. Prior to the hearing on the merits, the applicant sought summary disposition in this matter. Under TCEQ's procedural rules, which have been adopted by the State Office of Administrative Hearings, summary disposition shall be granted on all or part of a contested case if there is no genuine issue as to any material fact, and the moving party is entitled to summary disposition as a matter of law on all or some of the issues expressly set out in the motion or in an answer or any other response. The district's direct case includes evidence which supports the requested impact fee. Additionally, the executive director's direct case includes sworn testimony that the impact fee is reasonable and necessary and should be approved. Mr. Benavides had a full and fair opportunity to present controverting evidence, but did not do so. Therefore, OPIC agrees with the Honorable Administrative Law Judge that the uncontroverted evidence in the record shows that the impact fee proposed in the application is reasonable, equitable, and necessary as a mechanism to finance improvements to serve the designated service area and should be approved by the Texas Commission on Environmental Quality. As such, summary disposition was properly granted. Thank you, and I'm available for any questions.
Thank you very much. The applicant has, how much time, Mary? 4 minutes and 40 seconds for rebuttal.
Thank you. As Mr. Benavides actually did mention, the ALJ determined that our study supporting the impact fee was in fact timely filed in this matter. While we did submit the wrong study initially, we promptly corrected that once that mistake was found, and the ALJ accepted that study as supporting our request for the $5,160 impact fee. Crystal Clear has not increased their impact fee in over 13 years. This increase is necessary for them to function and run as a district, and so it's irrelevant as to whether or not this initial application was proposed by board members or management that resigned. So at this time, we ask that the commission grant Crystal Clear's application to amend its impact fee and levy the $5,163. Thank you.
Thank you. So the impact fee has been the same since 2013?
And possibly a little bit before that. It's remained the same since before Crystal Clear Special Utility District turned into a SUD. So it was the same. It was about $2,000 for a very long time.
Thank you.
Thank you.
item number 1 requires us to consider the ALJ's proposal for decision and proposed order concerning Crystal Clear Special Utility District's impact fee application to increase the fee from $2,500 to $5,163. I've reviewed the administrative record in this matter, including the pre-filed testimony and the pleadings, and I agree with ALJ's recommendation to approve the increased impact fee. Applicant has shown that it meets the applicable statutory and regulatory requirements, including that the fee is reasonable, equitable, and necessary. The protestant failed to file any evidence to the contrary. Therefore, I adopt the ALJ's proposed order approving the impact fee with the changes she recommends in her January 26, 2026 reply to exceptions letters. Colleagues, Tanya?
I'm in agreement that we should.
Katarina?
I'm also in agreement.
Thank you. Do I have a motion?
I move that we adopt the ALJ's proposed order as revised by the ALJ's letter dated January 26, 2026.
Do I have a second?
Second.
All those in favor say aye.
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 Thank you.
Item number 2 is the consideration of the application by Con Metal Concrete LLC for registration number 178619 under the Air Quality Standard Permit for concrete batch plants. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Right, item number 2. Before us, we have an application for a registration under the standard permit for concrete batch plants, which would authorize the construction and operation of a permanent concrete batch plant in Victoria County. When considering these types of application, the Commission first determines effectiveness. For these types of application, the legislature has directed the Commission to consider only those individuals actually residing in a permanent residence within 440 yards of the proposed plant as affected persons. The Commission received hearing requests from one individual in this matter, Mr. Elston Thomas Jr. In my review of his hearing request and reply, I found that Mr. Thomas did not provide the address of his residence and did not sufficiently demonstrate that he resides within 440 yards of the proposed plant, which is the threshold for being granted a hearing. So accordingly, I agree with the ED and with OPIC that Mr. Thomas's hearing request should be denied. I also recommend that we deny the request for reconsideration on this matter, as they do not raise new, relevant, and material information for the Commission to consider. I believe that the ED considered and sufficiently responded to the concerns in her response to comments. And finally, I adopt the ED's response to comment and issue the permit. Katarina, thoughts?
I'm in agreement.
Commissioner Miller?
In agreement.
Do I have a motion?
I move that we deny all hearing requests and requests for reconsideration, adopt the executive director's response to comment, and issue registration number 178619 under the Air Quality Standard Permit for concrete batch plants to Con Metal Concrete LLC as recommended by the executive director.
Do I have a second?
A second?
All those in favor say aye.
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 The motion passes. Right, we'll move on to item 3. Let everyone shuffle.
Item number 3 is the consideration of the petition by Dacuri Estates LLC for the creation of Caldwell County Municipal Utility District Number 10. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Before us, we have a petition by Dacuri Estates for the creation of Caldwell County MUD number 10, which would include approximately 313 acres in Caldwell County. The commission received hearing requests from several individuals in this matter. When considering hearing requests for district creation petitions, we must determine whether a hearing requester is an affected person who is entitled to a hearing. To be considered an affected person, a requester must explain how they will be affected by the application that is not common to members of the general public. They must also explain what personal interests they have that will be affected by the application. I agree with the ED and OPIC that we should grant the hearing requests of Edward and Tammy Barziza, Samuel Busa, and Charles and Judith Youngkin. So I refer this matter to SOA for a contested case hearing on the petition, and I'd also refer this matter to our ADR program to run concurrently with the SOA process. I deny the remaining hearing requests because, in my view, they do not either explain how they would be affected by the application in a way that's not common to the general public, or fail to identify an interest in the application that's within the Commission's jurisdiction to address at a hearing. Commissioner Gonzalez, thoughts?
I see that the same way.
Thank you. Commissioner Miller?
In agreement.
Thank you. Can I get a motion, please?
I move that we grant the hearing requests of Edward and Tammy Barziza, Samuel Busa, Charles and Judith Youngkin. We deny all remaining hearing requests, that we refer the petition to the State Office of Administrative Hearings for a contested case hearing, and that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts.
Do I have a second?
Second.
All those in favor say aye.
Aye.
The motion passes. Thank you. Katerina, your tech is working well.
Yeah, it's going well today.
Don't jinx
Something had to go well today.
Yes, I probably just jinxed it.
Okay. Item number 4 is the consideration of the petition filed by Berry Creek Land Investment, LLC, for the creation of Williamson County MUD number 68. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
The item before us is a municipal utility district creation matter proposed to be located entirely in Williamson County. The petition includes a request for road powers. Williamson County is the sole hearing requester. For district creation matters, we look only to whether the hearing requester is entitled to a hearing, and TCEQ rules provide factors for the commission to consider. When considering whether a governmental entity is affected, the commission considers the entity's statutory authority over or interest in the issues relevant in the application. I believe that the county adequately explained its statutory authority and the interests relevant to this application, including its authority over roads, including drainage and public roads. First, the commission is charged with considering the impact of a proposed district on natural runoff rates and drainage when it reviews petitions for district creations, which is relevant to the county's road concerns. Also, the request for road powers in the application requires the commission to consider the layout of road facilities, the petitioner's cost analysis, and the amount of bonds necessary for the road facilities, and whether they are financially and economically feasible for the district. And I believe Williamson County also sufficiently linked this consideration to its road authority. And colleagues, it is not lost on me that with a swipe of our pens, we can create an entity that can tax its citizens. I do not take that authority lightly. I believe that Williamson County has demonstrated that it is an affected person and recommend that we refer this matter to SOA. I'd also recommend a referral to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA process. Interested to hear thoughts. Commissioner Gonzalez.
After reviewing Williamson County's hearing request and the responses, I would deny the request. Similar to the position I've taken in the past, I don't think that the county's statutory authority alone makes it an affected person. Though we must consider their statutory authority among other factors, I do not believe that statutory authority alone requires us to grant the hearing request. And I don't think that the county has demonstrated a personal justiciable interest here. Therefore, I don't think that it's necessary to put all the parties through a resource-intensive contested case hearing and would deny Williamson County's hearing request. I've also reviewed the ED's technical memo and other documents supporting the petition, and I believe that the information shows that the proposed district is feasible, practical, and necessary, and would be a benefit to the land to be included in the district. I would also approve the district's request for road powers and appoint the temporary directors listed in the ED's technical memorandum. However, if my colleagues do not agree, I would like to request that we at least specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Thank you very much. Commissioner Miller?
I likewise would deny Williamson County's hearing request. While governmental entities may be considered affected persons pursuant to our rules, it is important to note that it is not a shall. An affected person analysis is still required. In my view, local governments need to do more than simply provide a list of their statutory authority. I do not want to become the practice of local governments when seeking affected person status. To be considered an affected person, the county must show it has met the requirements of 30 TAC 55.256A. I do not believe the county has met those requirements. The fact that the county has statutory authority is not the end of the personal justiciable analysis. That authority must relate to the creation of the MUD, and the personal justiciable interest must result from that authority. In this case, the county's request does not sufficiently explain how the county's statutory authority will be impacted by the creation of the MUD. Instead, it raises general potential concerns about the development of new districts in the county. In addition, the county raises a concern outside the jurisdiction of this commission, such as including a consent and development agreement, the CDA. The commission cannot consider or require the items that the county wants to include in the CDA. They are simply outside of our jurisdiction. So I have real concerns about going through the time and expense of a hearing when the only express concern that the county articulated cannot be resolved through the process it is seeking. Neither the application process nor SOA are the appropriate venue for litigating the county's general concerns with new development or the desire for a CDA. As such, I conclude that the county has not raised a personal justiciable interest, which is necessary for affected person status and a hearing.
Thank you, Commissioner Miller. Do you have a motion?
I do. I move that we deny the hearing request of Williamson County, grant the petition for creation of Williamson County Municipal Utility District Number 68, find that the petition satisfies all applicable statutory and regulatory requirements, and the district is feasible, practical, and necessary, and would be a benefit to the land to be included in the district. Approve the district's request for road powers in accordance with Texas Water Code 54.234, and appoint the following 5 people to serve as temporary directors until permanent directors are elected and qualified. Joe William Heathcott, 2, the second. Emily Pantusuo, Kylan Court, Dallas Smith, and Peter Sylvester.
A second.
All those in favor, say aye.
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 Nay. The motion passes. Thank you. We will move on to item number 5.
Item number 5 is the consideration of the application by 306 Properties LP for new TIPD's permit number WQ0016471001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right. This matter involves an application for a no-discharge permit that would authorize the disposal of treated domestic wastewater by land application on 78 acres in Comal County. The commission received one timely hearing request and request for reconsideration from Mr. Robert and Katrina Oldham. When considering hearing requests for these types of applications, the commission considers that two-step analysis I explained for item number 2 earlier this morning. To be considered an affected person, a requester must explain how they will be affected by the application in a way that is not common to members of the general public. For this type of application, the hearing requester must also file timely comments and a hearing request that identify their personal interests and concerns that they have. The identified concerns must be within the Commission's jurisdiction to address in the authorization. In this matter, the Oldhams reside less than a quarter of a mile from the proposed land application site, and they raised concerns related to the health of their family and nuisance odor. I believe that Oldhams qualify as affected persons and identified concerns within the Commission's jurisdiction for this authorization. So I would grant the hearing. Commissioner Gonzalez, thoughts?
I'm in agreement.
Commissioner Miller?
In agreement.
All right. Moving on to the second part of our analysis on issues, the Oldhams raised relevant and material issues regarding odor and health impacts. These issues are within our jurisdiction to consider for this type of permit, and I would recommend their referral. The water supply concerns raised by the Oldhams are specific to drawdown concerns and water availability, which are not within our jurisdiction for this application. So I would not refer the issue regarding water supply. The remaining issues are also not within our jurisdiction to refer. Commissioner Gonzalez, any thoughts on that?
Yes, but I was thinking that we would refer the issues on nuisance order to SOA.
Commissioner Miller?
I was thinking the same thing.
Okay. All right, I agree. Thank you. And finally, I would recommend a 180-day hearing duration, and I would also recommend denial of the request for reconsideration since the RFR is identical to the hearing request and does not introduce new relevant and material issues to consider. Do I have a motion?
I move that we grant the hearing request of Robert and Katrina Oldham, that we deny the request for reconsideration, that we refer the matter to SOA for a contested case hearing on the following issues: whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13, and whether the draft permit will be protective of the health of the requesters and their family. That we specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision, and that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process.
Do I have a second?
Second.
All those in favor say aye.
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 Thank you. All right, moving on to item 6, please.
Item number 6 is the consideration of the application by Midwest Sterilization Corporation for renewal of air quality permit number 55557. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Item 6 before us today involves a renewal application for an air permit for an existing medical equipment sterilization operation. The application received numerous hearing requests and a request for reconsideration. For these type of renewal applications, by statute, the Commission must first consider whether a right to a hearing exists. I agree with the analysis of the ED, OPIC, and of the applicant that no right to a hearing admitted not previously admitted. The backup materials also do not indicate any compliance history concerns. I do not find that the request for reconsideration raised any new information for the ED to review, and I believe that the ED's RTC adequately addresses the significant public comments filed on this renewal applications. Commissioner Gonzalez, any thoughts?
Yes, I agree with the ED, OPIC, and the applicant that no right to a hearing exists on the renewal of the air permit for the applicant's existing medical equipment sterilization operation. There's no right to a hearing on this application because the renewal does not involve an increase in emissions or authorize new contaminants, and the facility has a high performer compliance history. In addition, I agree with the ED's determination that applicant demonstrated that the draft permit meets best available control technology and will continue to be protective of human health, welfare, and the environment. I will also note that a new national emission standards for hazardous air pollutants was recently implemented in 2024 for commercial sterilizers setting more stringent requirements for capturing and controlling off-gassing emissions, which is expected to reduce ethylene oxide emissions. As the ED asserts, TCEQ intends to implement the new federal standards, which will require the applicant to comply with these requirements before the compliance date, in addition to state requirements. I believe that the request for reconsideration raises no new information to review, and the ED's RTC adequately addresses the public comments filed on this renewal application. Therefore, I believe that we should deny all requests, issue the permit, and adopt the ED's response to comments.
Commissioner Miller.
I agree that there's no right to a hearing in this instance.
Thank you. Do I have a motion?
I move that we find that no right to a hearing exists on this application, deny all hearing requests and the request for reconsideration, grant the renewal of air quality permit number 55557 to Midwest Sterilization Corporation as recommended by the Executive Director, and adopt the Executive Director's response to comments.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. We'll move on to the enforcement docket.
Okay, that takes us to enforcement, which are items 7 through 35. The Executive Director's staff is here to present these matters.
Good morning.
Morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sotomayor, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 7 through 35. The total assessed administrative penalties are $1,257,184, with $183,948 deferred, $479,849 applied towards supplemental environmental projects, and $593,395 to the general revenue. We respectfully request approval of these items and are able to answer any questions you may have.
Thank you very much. Commissioners, any questions? Nope. All right. I move that we adopt item.
We have people signed in to speak.
Thank you.
Nope, that's okay, and we have OPIC still too. So on items 10, 12, 13, and 15, there are people who are signed in and available for questions. And on number 9, we have a 3-minute time limit on comments from speakers today.
Ms. Oldham, are you there?
Yes, can you hear me?
We can hear you.
Hello, good morning, Commissioners. Excuse my voice, I have a cold. I am Melanie Oldham. I'm the director with a small nonprofit called Better Brazoria Clean Air and Water. I live in Freeport, Texas, where the BASF facility is located, and I want to speak on the supplemental environmental project selected. Freeport is an environmental justice community that suffers disproportionately from air pollution. 65% Hispanic, Black, white, and we're very low income. Some of the largest industrial polluters in the county are located in Freeport. They emit pollutants including VOCs, benzene, particulate matter, and our county, Brazoria County, is non-attainment for ozone. While supplemental environmental projects are a meaningful way to help communities harmed by pollution receive some direct benefit from successful enforced actions. The closest SEP is in Texas City and is 48 miles away. SEPs are currently structured to allow polluters to fund projects in areas that are not even directly affected by their environmental harm. In order for a community member to be granted affected party status, we have to demonstrate that we live within a mile or so radius of the facility. It is not faithful to the SEP program to assign a benefit to a community that did not suffer harm. The agency offers an easy remedy to this issue, and that is the option for a custom SEP. It's a little lazy for any polluter not to engage with the local school districts here in Freeport or Brazosport to determine the potential to make a real impact on the impacted community instead. I, along with the advocates at Public Citizen, believe the SEP program is a good thing and that communities could really benefit from the fundamental concept. We welcome the opportunity to start a dialogue with BASF and the school district on a custom SEP and appreciate that they've made use of this program. But the agency should also make it a priority to find ways to encourage polluters to put those funds directly into the communities they are harming. Thank you.
Thank you, Ms. Oldham. Any questions or comments for Ms. Oldham? Nope. All right. Mary, anyone else signed in on these items?
No one else has signed in.
Right.
Go to OPIC.
OPIC.
Hi. Good morning again, Chairwoman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and staff. For the record, I'm Sheldon Wayne with Office of Public Interest Counsel. Our office has reviewed these items, and after review, we recommend approval of all items. We thank the Executive Director's staff for their hard work on this.
Thank you very much. I guess I'm just eager to pass this docket today. I appreciate the work that has gone into moving these orders forward. I'm prepared to adopt them. Colleagues?
Yes, I'm also prepared to adopt them, and I'm glad to see Houston Housing Authority taking corrective action on that site in Houston. As a Houston native, that's great. So many thanks to staff for their efforts to get them to agenda today.
Commissioner Miller?
I'm in agreement.
I move that we adopt items 7 through 35 as recommended today by the Executive Director. Do I have a second?
A second?
All those in favor say aye.
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 Thank you. Thank you, ladies.
Item 36 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present the matter.
I think I threw my colleagues off with only one agenda this month. All right. Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sotomayor of the Enforcement Division, and with me are Megan Hamilton of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2026 through January. There were 650 effective administrative orders issued, and of the amount of $6,986,732. $3,476,805 are to be paid towards supplemental environmental projects. 6,416 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 522 enforcement action referrals have been received. There were 2,866 pending administrative orders with 1,385 cases that are on the backlog. 162 cases are pending at the Attorney General's office for representation in district court, and 5 judgments have been issued. 1,739 cases are being tracked for compliance. We're available to answer any questions.
Thank you very much. Any questions, ladies?
Thanks, Amy.
All right, do we have anyone signed in on this item?
No one has signed in.
OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and ED staff. For the record, I'm David Timberger, Interim Public Interest Counsel. OPIC has reviewed the report and appreciates the efforts of staff to move these cases forward. Thank you.
Thanks, David. I'd also like to thank OCE and OLS for their continued enforcement efforts, as well as this report. Colleagues, do you have any questions or anything you'd like to add?
Thanks as always, Amy.
Thank you.
Okay, no action is required on this item. Mary, you can call the next item, please.
Item number 37 is the consideration of a petition for rulemaking filed by Oberon Fuels Incorporated to amend 30 Texas Administrative Code Chapter 321 to allow the disposal of mortalities in an ED-approved wastewater system. The petitioner, interested individuals, we do have one person signed in to address the commission. The ED and OPIC will each have 5 minutes to address the commission, and the petitioner may speak first and reserve a portion of time for rebuttal. With that, we'll begin by calling on a representative of the petitioner to come speak.
Good morning. Good morning, Chairwoman, Commissioners, Executive Director Staff, OPIC, and General Counsel. My name is Brian Shaw, and I'm here today representing Oberon Fuels. And with me today is Wendy Merkin, who is the Director of Project Engineering for Oberon Fuels. So thank you for the opportunity to discuss this petition. Oberon Fuels is developing renewable fuels in Texas and doing so to convert agricultural waste streams into useful energy products. In the course of this work, Oberon has identified an opportunity within the current Confined Animal Feeding Operation, or CAFO, rules to align with federal regulations. Under current Texas rules, disposal of mortalities in liquid processed wastewater systems is prohibited under 40 CFR Part 412 EPA. However, in this section under 412, EPA allows this practice when the alternative technologies are properly designed and approved by the Executive Director. The petition seeks to align Texas rule with existing federal regulations while maintaining oversight through Executive Director approval of specific appropriate technologies. In preparing this petition, EPA was allowed to review a proposed draft and we requested their feedback on that. And they were indicated they were likely to accept it on the basis of it being consistent with applicable federal requirements. So this doesn't do anything beyond what is currently allowed within the federal requirements. Processing mortalities in anaerobic digesters can provide operational and environmental benefits to agricultural operations and the communities alike, including enclosed processing that reduces odor potential, elimination of scavenging by birds and vermin, reduced risk of disease transmission, and improved nutrient recovery for beneficial reuse. The proposed change would provide a supplemental and voluntary option for operators with properly designed digesters in alignment with federal rules. It would not require existing operators to adopt this approach or to deviate from other existing appropriate approved methods. The proposed change is intended for routine daily mortalities and routine culling, not for mass mortality events, which would continue to require special handling and disposal. So this would not impact any of those types of events. And finally, in closing, I thank you for the consideration of this. I'm happy to answer any questions, and we would like to reserve any time for rebuttal. Thank you for your consideration.
Thank you, Mr. Shaw. Any questions for Mr. Shaw at this time? Okay, thank you very much.
We have Isabella LaCicero signed in.
Hello, Commissioners. Can you hear me?
Yes. We sure can.
All right. I'm Isabella LaCicero with Public Citizen's Texas office. Public Citizen is a nonprofit consumer advocacy organization with over 1 million members and supporters that champions public interest in the halls of power. This petition for rulemaking caught our attention not only because it seeks to allow disposal of deceased animal carcass in liquid manure and wastewater systems, in this case through a manure digester, but also because Texas Agriculture Code Chapter 161.004 relating to the disposal of deceased livestock carcasses, Section B states that the Texas Commission on Environmental Quality may not adopt a rule related to the disposal of livestock unless the rule is developed in cooperation with and is approved by the Texas Animal Health Commission. TCEQ's rule petition package makes no mention of collaboration with the Texas Animal Health Commission, and a review of that agency's rule proposals and recent agenda items recently makes no mention of a rule to amend the code or collaborate with the TCEQ on any such rulemaking. So we'd like to understand whether the agency intends to open this rulemaking and then wait for its next quarterly meeting in May for approval or proceed without it. We know that CAFOs pose multiple water quality problems, and manure digesters bring their own. Dead animals are not inert waste. As you are aware, carcasses can contain pathogens, antibiotics, and extremely high concentrations of organic material that can present potential contamination and other biological hazards. The legislature of Texas understood this, which is why there is a strong preference in the legal literature for rendering or composting of animal carcasses. The burning required in those processes reduces the risk during disposal. The anaerobic digesters are not worth the needed methane production in pursuit of biofuels. These biofuels are not clean. We'll also Note that this letter states that the petitioner, Oberon, is developing facilities in Texas, but the company only shows one location in the central registry, which is in the Houston area. But that facility does not have a CAFO registration, nor does it have a water quality authorization for the wastewater process it needs in its petition letter. Maybe that particular facility doesn't need those authorizations. We think it is significant that a company with no authorizations in Texas and no track record of safe operations could be the impetus for creating a new rule for novel disposal methods of cattle carcass in a high-risk zone so close to the growing hypoxic zone of the Gulf. And lastly, if that is the case, we wonder if it's worth the agency's time to open an entire rulemaking for just one facility. While the proposed rule amendment would grant the executive director discretion, we believe that every authorization this agency issues, while it remains unable to respond properly to reported environmental complaints or resolve its extensive enforcement backlog, is one more authorization than this agency can effectively regulate. Thank you.
Okay, that is the only person from the public signed in on this. We would next go to the ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division, and with me today is Michael Parr with the Environmental Law Division and Greg Easley, also with the Water Quality Division. Before you today for consideration is a petition for rulemaking requesting the Commission amend 30 Texas Administrative Code, Chapter 321, Control of Certain Activities by Rule, Subchapter B, for concentrated animal feeding operations. The petitioner requests that we amend Chapter 321, Subchapter B to remove the existing prohibition on the disposal of animal mortalities in a liquid manure or process wastewater system in order to allow TCEQ to consider proposed technologies to process mortalities at individual concentrated animal feeding operation or CAFO facilities and evaluate whether they could be implemented in an environmentally protective manner. TCEQ's existing CAFO rules are derived from the U.S. Environmental Protection Agency's CAFO mortality handling rules, located under Part 412 of the Code of Federal Regulations. These federal rules do allow for an exception to the prohibition where alternative technologies are evaluated and approved to handle mortalities. As such, staff respectfully recommends granting this petition to amend Chapter 321. Granting this petition and conducting the requisite rulemaking would enhance TCEQ's regulatory flexibility and ensure continuity and consistency with federal requirements. We would, of course, conduct any required consultation with any other agencies that were necessary when conducting said rulemaking. Thank you for your consideration. We are available to answer any questions you may have regarding this petition.
Thank you. Any questions for ED staff?
No, just thank you for pointing out that we will do the necessary coordination at the proper time.
Thank you.
OPIC?
Good morning, Chairwoman.
Morning.
Commissioners Miller and Gonzalez, General Counsel and Executive Directors, Attorney, and staff. My name is Eli Martinez. I'm Senior Attorney with the Office of Public Interest Counsel for the record. OPIC has reviewed Oberon Fuels' January 12, 2026 petition, and we support the initiation of rulemaking. The petition seeks to amend 30 TAC 321.39G3, which governs carcass disposal at concentrated animal feeding operations. Specifically, it requests adding an exception to the current prohibition on disposing of animal mortalities in liquid manure or processed wastewater systems, allowing such disposal if the system is adequately designed to contain and treat carcasses and the facility has been approved by the ED for that use. This aligns with federal flexibility under 40 CFR 412.37A4 and 412.31A2, which permit approved alternative technologies. OPIC supports initiating this rulemaking because it advances the public interest by enhancing environmental protection, promoting innovation in waste management, and ensuring consistency with federal standards while maintaining safeguards against unauthorized discharges under Texas Water Code 26121. Under current TCEQ rules, CAFO operators are strictly prohibited from disposing of mortalities in liquid manure or processed wastewater system. This mirrors the EPA's baseline prohibition, but lacks the federal exception for case-specific approvals of alternative technologies. As noted in the ED's recommendation, this gap limits TCEQ's ability to evaluate and approve innovative methods such as manure digesters that could handle mortalities in an environmentally protective manner. The petition highlights a practical barrier. CAFOs often rely on composting, which can lead to odors, scavenging by wildlife, potential disease spread, and contamination of wash water, or groundwater. In contrast, approved digester systems could process daily mortalities and routine culling, excluding the mass die-offs, more effectively. Initiating rulemaking would provide a TCEQ with the flexibility to review proposals on a facility-specific basis, ensuring compliance with Texas Water Code 5.102, 5.103, 5.105, and 5.120, which emphasize conservation, environmental quality, and permit issuance to prevent pollution. From a public interest perspective, this amendment may offer environmental and health advantages by reducing odors and nuisance, because enclosed digesters may minimize odors compared to open composting, which would improve community livability near CAFOs. Prevention of disease and contamination by eliminating scavenging, which poses risks of disease transmission and surface or groundwater pollution, resulting in the protection of natural resources, as we are mandated to do by Texas Water Code 5.120. Nutrient recovery and sustainability, because digesters enable beneficial reuse of nutrients, supporting renewable fuel production and aligning with Texas goals for resource conservation under Texas Water Code 5.013, and alignment with federal standards, harmonizing state rules with EPA exceptions, which can promote regulatory efficiency without compromising protections, allowing TCEQ to approve technologies vetted for environmental safety. OPIC emphasizes that any approvals should prioritize public health, water quality, and contain nuisance conditions such as odors, with rigorous ED oversight to prevent hazards. The ED's memo justifies granting the petition, and initiating this process allows critical stakeholder input, including from the Animal Health Commission, technical review, and balanced amendments, ensuring no undue burden on the public while fostering innovation. For these reasons, OPIC recommends that the Commission initiate rulemaking, and I'm available for any questions.
Thank you. Any questions for OPIC? Mr. Shaw, you have 2 minutes and 36 seconds left, should you decide to take.
Thank you. Thank you for the thoughtful review, and especially thank you, OPIC, for a very thorough analysis of the public interest component of this rulemaking. We'll just make a couple of points. One, I want to reemphasize that this would not be intended to allow for digesting of diseased animals in a mass die-off, and so there would be no additional concern about it changing the rigor and the ability to ensure protectiveness whenever those issues are dealt with. Also, the fact that in the current operation, the digesting would occur within the footprint of the CAFO, a similar way the composting occurs, and so we're really not introducing anything outside of what is already captured in the area to where there's not a chance for this change, providing additional opportunities for things to escape, if you will, the CAFO. This would still maintain the no discharge component of that, so this would not add any burden outside of the CAFO. And as was mentioned before, the digester provides a much more controlled process, which is therefore less likely to lead to upsets and intrusion by vermin and other scavengers that can cause odor and or potential outbreaks or disease of disease within that facility. So for all those environmental benefit reasons, we appreciate your discussion and hope that you'll grant this petition. Thank you.
Thank you, Mr. Shaw. I think it would be worthwhile for the ED to further explore revising our rules to offer the same flexibility that appears to be available in the NPDES program. So I would initiate rulemaking, noting that this doesn't mean that we would adopt the rule as proposed in this petition for rulemaking or adopt any rule after looking into it more closely. But I do believe that the petitioner has raised an idea that should be explored. So I'd grant the petition and direct the ED to initiate rulemaking. Colleagues?
I agree. While the federal rules similarly prohibit carcass disposal and liquid manure and processed wastewater, they also make an exception if alternative approved technologies are being used. I think the ED provided a sufficient statutory basis for this potential change. I think that pursuing this rulemaking could give TCEQ similar case-specific flexibility, allowing it to consider and potentially approve the use of technologies when determined to be environmentally protective. So I think it would be beneficial as well for the executive director to initiate rulemaking to examine the issues raised.
Thank you, Commissioner Gonzalez. Commissioner Miller?
I agree. I think this rulemaking has the potential to lead to the use of alternative technology, which may actually lead to improved environmental protection. So I look forward to us exploring it.
Thank you. Excellent. Do I have a motion?
I move that we direct the executive director to initiate rulemaking to examine the issues raised in the petition for rulemaking filed by Oberon Fuels, Inc. concerning amendments to 30 Texas Administrative Code, Section 321.39.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Motion passes. We'll go to the rule matter, item 38.
Item 38 is the consideration for publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 37 regarding financial assurance, and the creation of a new section of 30 Texas Administrative Code, Chapter 328 regarding waste minimization and recycling. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jarita Sepulvedo with the Waste Permits Division. With me is Matthew Hopper with the Environmental Law Division, and Charlie Fritz and Umair Hassan with the Waste Permits Division. The proposed rulemaking would implement reporting, cost estimate, and financial assurance requirements for renewable energy component recycling facilities promulgated in House Bill 3229 from the 89th Texas Legislature 2025 regular session. A hybrid public hearing will be offered on this proposal in Austin and online on April 23rd, 2026. Staff respectfully recommends approval to propose the publication of and hearing on amended Section 37.931 of 30 TAC Chapter 37 Financial Assurance and new Subchapter M in 30 TAC Chapter 328 Waste Minimization and Recycling. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you very much. Any questions for the ED staff?
No.
Mary, has anyone signed in on this item?
We don't have anyone signed in on this one.
OPIC?
Hi, good morning again, Chairwoman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. Excuse me. I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC has evaluated this proposed rulemaking and agrees with the Executive Director that it should proceed forward for publication and the taking of public comment. OPIC understands that the Executive Director has determined this proposal is necessary to appropriately implement HB 3229, passed by the 89th Texas Legislature in 2025. We note that a public hearing for this rule proposal is planned for April 23rd, 2026, and we intend to monitor public comments that the Commission receives as this process unfolds. Furthermore, a public involvement plan and Spanish language documents will be required. At this time, OPIC is supportive of this rulemaking because the public will benefit from having rules that are consistent with state law, and the rulemaking appears necessary for TCEQ to implement the statutory requirements in an appropriate manner that is consistent with its existing financial assurance procedures and recycling programs. It will also ensure the agency can utilize financial assurance funds provided by the recycling facilities when necessary. Thank you, and I'm available for any questions.
Thank you. Any questions for OPIC? The proposed rulemaking implements House Bill 3229 from the 89th Texas Legislative Session. The bill establishes new reporting, record-keeping, financial assurance, and penalty requirements for renewable energy component recycling facilities. Rules are necessary to implement this legislation. To fully implement the financial assurance program, staff has proposed some rule provisions to fill some gaps where the bill is silent. These provisions appear to ensure that these new rules are consistent with our rules for other similar agency programs, ensure enforceability, and are within the agency's statutory authority to adopt. I welcome public comment on this item and specifically invite comment regarding these proposed additions. Therefore, I'd recommend that we approve the publication of and hearing on the proposed amendments to Chapter 37 and new sections of Chapter 328. I'll pause here. Commissioner Gonzalez, thoughts?
I I agree, and likewise, welcome comment on whether we're following legislative intent with the additions.
All right, I move that we approve the publication of in hearing on amendments to 30 Texas Administrative Code, Chapter 37, Financial Assurance, and the creation of new sections of 30 Texas Administrative Code 328, Waste Minimization and Recycling, as recommended by the Executive Director. Do I have a second?
A second.
All those in favor say aye.
Aye.
Aye. Thank you.
Thank you.
Motion passes. On to public comment.
Yes, the commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code, Section 5.112, except for pending permitting matters or other contested cases, which are subject to the ex parte prohibition found in Texas Government Code, Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and recitation of existing policy. We have one person signed in for public comment session, Catherine Guerra.
Ms. Guerra?
Good morning, Commissioners. I'm Catherine Guerra with Public Citizens Texas Office. I serve as the Director of the TCEQ Watchdog Campaign, an agency accountability and community capacity building initiative we launched last year. We've been closely monitoring the agency in that year and have published a review of the agency's performance across its core functions: enforcement, rulemaking, permitting, and public participation. We're tracking everything from votes to the rationale used to deny affected party status to every comment on every rulemaking. And what we have found is concerning. Some might call it an indictment of this agency, and what it shows is a failure of our state's environmental regulator to perform its most fundamental function: protection of human health and the environment. And while the TCEQ and its leadership abandon their duty to protect residents and disregard public input as the bureaucratic box they must check before they bend to industry, we want communities to know we hear you. We're inviting the public to not only read our review, but also join us on Monday, March 30th at 6 p.m. to dive into the data and discuss your community's concerns about the TCEQ. Both the agency review and event registration are available on our website, citizen.org/Texas. I'll share some of the highlights of our finding, all which comes from publicly available data published by the TCEQ, using the remainder of my time. In 2025, the TCEQ conducted the fewest number of on-site investigation it has conducted in the past 8 years, even during the pandemic, conducting 3,600 fewer investigations than in 2024 and 5,200 fewer than in 2023. Despite foregoing several thousand on-site investigations, communities could not count on the TCEQ to promptly respond to reported environmental complaints. The agency responded to just 300, or 3% of 9,000 complaints within 24 hours last year, and the majority of those complaints, 54%, took 30 or more days for an initial response. The agency has a backlog of nearly 1,400 enforcement cases, more enforcement cases than it issued for the entire year in 2025, and the agency should be working to achieve immediate compliance in those cases. TCEQ dismissed 100% of the comments it received from residents and advocates on sunset-required rulemakings, including the public participation rulemaking, rules that were drafted by the same TCEQ staff that the Sunset Commission said lacked sufficient consideration of the community's interests to begin with. Those rules were, however, modified in response to industry comments. Commissioners voted to deny 40% of the contested case hearing requests it received last year, despite OPIC recommending that commissioners grant 62% of the denied requests, meaning TCEQ commissioners ignored the recommendation to protect the public's interest more often than not. Communities deserve more. Legislators thought so too, and this agency must be accountable to the people. So we look forward to hearing more from communities and to engaging with legislators about how TCEQ's weak enforcement regulatory approach harms communities across Texas on March 30th. Visit citizen.org/Texas to register for our community discussion. Thank you.
Okay. I find your comments, Ms. Guerra, incredibly offensive to the 3,300 TCEQ staff who work tirelessly to make sure that this environment is protected. Commissioners, any thoughts, comments?
Well, I appreciate her compiling some of the data. I don't agree with the extrapolation of it. the way that it's being presented. I also find it pretty offensive to our 3,300 employees across the state that I think do a phenomenal job at just helping the state and serving the state. And I just want those employees to know that I appreciate their efforts. And just because a group with a very small following doesn't feel the same way, it doesn't denigrate what you do whatsoever. So thank you.
Well said. Commissioner Miller?
I would just agree that our staff, and having been staff at this agency, I know how hard y'all work, and please keep doing your jobs. I know you believe in our mission and carry it out well.
Thank you. Well said as well. With that, is there anyone else signed in for public comment?
No one else is signed in.
All right. We'll move on to items 40 to 43. This commission will meet in executive session. Therefore, this meeting stands in recess.
And let me announce where. So we'll be meeting in room 4222 of Building F at approximately, I'm going to say 10:50, as permitted by the Open Meetings Act, including Texas Government Code Sections 551, 071, and 074, to take up and consider the matters noticed as you noted in 40 through 43.
Excellent. Thank you. This meeting stands in recess. The time is 10:36 a.m. Thank you.
The commission met in room 4222 of Building F for closed session from 10:52 a.m. until 11:05 a.m. on item numbers 40 through 42, as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned. The time is 11:25.